I would also like to use this opportunity to say thank you to CAA and ProfNet Network, especially to Professor Silji, that he succeeded to gather us in this group team, and Professor Billets, and especially for this inspirative speech before me. So my presentation today is prepared regarding the equality in an ever-integrated Europe in general terms, actually efficiency of judicial cooperation or better protection in civil matters. This presentation does not aim to provide a comprehensive overview on that cooperation and protection, but rather to put framework of that cooperation. And regards to this presentation, firstly explains what does the judicial protection mean, and later on what measures have been set in order to achieve the aim of efficiency. What does it, from the very beginning of the European family of states, judicial authority has an important role in guarding the fundamental rights. Even though the right of efficient justice as such was not explicitly provided in earlier European legal acts, there was no doubt that justice per se was not enough if it not efficient. Hence, nowadays, efficient justice has a strength of fundamental rights. But when it comes to European Union, it is worth to say that the complexity of the EU framework of judicial protection makes efficiency hard-reaching goal. Namely, the current framework is composed of various partially overlapping legal norms with particular content, structures, purposes, and this framework also essentially rests on the distribution of exclusive jurisdictions between supranational and the national courts, as well as further distribution between the national courts themselves. When it comes to decentralized enforcement, the system is functional, but from the other side, regarding the integrated or shared procedures, the current framework shows certain difficulties in achieving efficient judicial protection. In order to analyze an impact of the current framework, I will just in short refer to the source or main source of principle of effective judicial protection. First one was proclaimed by Court of Justice as general principle of the community law, which underlies the traditions that are common to the member states as they reflected in Article 6 and Article 13 of European Convention on Human Rights. Hence, that was just the general principle. Article 19 of the Treaty of the EU states that the Court of Justice for EU has the task to ensure that interpretation and application of the treaties, the law is observed, as well as the member states shall provide remedies sufficient to ensure effective legal protection in the fields covered by union law. Finally, Article 47 of the Charter of Fundamental Rights of the EU proclaims the fundamental right to an effective remedy and to fair trial. Obviously, by adopting later acts, European Convention on Human Rights seeks to be privileged source for making clear what common traditions are, but rather the rule of privileged source of interpretation of mentioned provisions of the Charter. In order to analyze an impact of the current framework, I will just in short refer to the sources, actually to the rights which are essential part of justice. Some of them are the right to access the court, which basically means the right to bring an action. Further, the right of defense, the right to a fair trial, which means right to hearing, the right to an independent court, the right to comprehensive judicial review, which is very important right regarding this cooperation and protection, judicial protection, and that means examination of all facts and legal issues that might be relevant to settle the dispute. The court must have power to consider all the questions of facts and law that are relevant to the case. And these rights has their own limitations as such, which is not the topic of this presentation, but we will be elaborate in chapter in forthcoming book. If we consider these rights in the context of the EU framework, efficient judicial means that the member states has obligation to ensure minimum level of limitations when they implementing EU law according to Article 47, and according to Article 19, member states shall provide remedies sufficient to provide effective legal protection in the fields covered by Union law. So in first article that I cited, that was just when they implementing EU law, and in the other it's a little bit wider, since in all fields that covered by Union law. Court of Justice of European Union interpreted this provision in a way that fields covered by EU law must be understood in a way irrespective of whether the member states are implementing Union law within the meaning of Article 51 or not. Precisely, courts has to enshrine effectiveness on both levels, EU and member state, and therefore legal remedies and procedures are designed to permit Court of Justice to review legality of measures adopted by the institutions. The court concluded this as long as direct action against national implementing measures before national courts, and that could give rise to the latter making reference for preliminary rulings on the validity of secondary law that might not be possible to challenge in the form of annulment action before the Court of Justice of EU. The Court of Justice stated that when reviewing the action of domestic authorities aimed at enforcing a foreign act, Article 47 of the Charter requires the national court must have jurisdiction to review the legality of the latter. As regards efficient judicial cooperation, question is what should be done to achieve twofold goal and at the same time not to change current architecture of the United European Union. Twofold goal mean protection of right to justice as an essential right from one side, and from the other side make the justice effective in a very complex environment when exist multi-layered legal systems as well as courts with different integrations. To make things more complicated, it is not just a question of multinational and supranational court systems, but rather of a number of independent national courts whose decisions in some situations has to be enforced in another state, with bearing in mind the idea of united Europe as a community of equal but different. To put this in a language of a judicial authority, one member state is supposed...
Sorry.
It's not for me.
It's not for you.
Thank you. One member state is supposed to give power to foreign decision and therefore to foreign judicial authority. Having in mind that the European Union is the community of sovereign states with their own legal traditional legal systems and legal systems, it is obvious that cooperation could be settled just by common action. One of the measures with regard to this is mutual recognition. Mutual recognition is a part of the general principle of mutual trust, but it is put in judicial procedure. and it's settled in the heart of judicial cooperation towards the aim of effective justice for all citizens. Its explanation has legal and functional context. From the legal point of view, mutual recognition is supposed to produce legal effects in entire EU. Actually, in other from one to another member states. From the functional point of view, it could be explained in the context of the purpose of the European Union as such. That means that mutual recognition should have integrative function. Basically, mutual recognition provides automatically recognized recognition and enforcement of foreign decisions, judgments, whatever we talk about judicial cooperation, without needing additional procedure of verification. Of course, automatic does not mean in each case unconditional and absolute recognition. The first normative instrument was the Brussels regulation, officially Regulation 44 from 2001, on jurisdiction and recognition and enforcement of judgment in civil and commercial matters, was the first instrument adopted to promote judicial cooperation in civil law matters within EU. And this regulation states exceptions, actually situations where recognition could be refused, and some of them are public order, fair trial, and right to hearing. Developing effective judicial protection, Court of Justice interpreted exceptions in numerous cases. For example, in Apostolides case from 2007, I think, which concerned property rights, recognition was refused because judgment was brought in default of appearance. In other case, trade agency, courts refused recognition since defendant did not have sufficient time to take the necessary steps to avoid a default of appearance. Even though mutual recognition has been provided to develop fundamental rights in the context of European Union and to make integrative part of juridical authority, several problems arise from the current framework. First, and I think the most important, is the fact that enforcement of foreign decisions endanger sovereignty and independence of state of destination as well as the state of origin. Because each state, as Professor Willis already explained in criminal law, but it's a little bit, it's less visible in civil law, but it's as well presented, that each state made procedural rules as well as laws in accordance to their own interest. Maybe in civil law there is something more which is not visible in criminal law. That means that all civil law matters are not covered by laws, and sometimes it's not very easy to control or check if something is opposite to laws, but it could be opposite to some unwritten rules that is accepted in one society, in one nation, and that could be a part of public order. As I mentioned, public order, I have to explain that public order, which is the reason for refusal of mutual recognition, is very narrow interpreted, and that means just the case if the judgment could not be recognized if in another country there was no acceptable degree of free trial and right to hearing. All other situations which could be in one country be marked as public interest or public order, or better to say with civil law language, moral of society in business, then it could be recognized even though it would not be accepted in the country of destination. So I would like to finish with this question, which remains at the last slide, and it means efficiency of judicial cooperation. Is it warrant for justice? Because if we consider justice in national level in accordance with the national tradition in civil law, then we need to bearing in mind the fact that actually juridical procedure has to serve to the protection of those civil law matters within their citizens. Thank you a lot.